So good morning, folks. Welcome to LMTV Live from the grounds of the Supreme Court here in Monrovia. As you may be aware, today the Supreme Court is closing for the March Chamber of Court and also the official retirement ceremony for outgoing Chief Justice Siaren Yo is expected to take place today just at about 10 o'clock up here, and we are here to bring you live coverage. Today there is a different scene here on the grounds of the Capitol, not the Capitol but the Temple of Justice. As you will see, usually you have vehicles all parked here for justices and judges and some people who will have activities here at the Temple of Justice, but this seems to be a bit different today. Here you have to disembark the vehicle, and after which the vehicle will be sent down to the basement, and then you have to access the main building hosting the Supreme Court of Liberia. So I'm here with my colleague Aaron Talu. We are going to be bringing you the live coverage of the March Chamber Court as they close today, and also bringing you the official ceremony for the retirement of outgoing Chief Justice, Her Honor Siaren Yo. So wherever you are, we ask you to stick and stay with us as we go upstairs to position ourselves well to have this broadcast and the entire ceremony coming to you direct from the Liberia National Television. And we also it's expected that this program will go in two phases. After the March Chamber of Court, the March Chamber of Court, after their closing ceremony, it will be followed by the official retirement ceremony of Chief Justice, outgoing Chief Justice Siaren Yo. So stick and stay with us. This is LMTV, and we are here. Very shortly, we will be going upstairs to position ourselves as the official ceremony is expected to start at about 10 o'clock this morning. So this is a bit up to inform you that yes, there is a ceremony coming up, and
also the afternoon the newly confirmed Chief Justice will be commissioned by the President.
And this place is not a familiar ground to me, so I just been informed by my colleague Aaron Talu, who is also a judicial correspondent. I'm being informed that the Chief Justice who was confirmed by the House of Senate, that is Judge or Chief Justice Yami Kokwe-Gbesi, for the record, will also be commissioned today as official of the Republic of Liberia after the official retirement ceremony. That is also part of today's activity. So thanks for watching. My name is Ayusin Liba, and my colleague Aaron Talu jointly will be bringing you this coverage from the Supreme Court of Liberia as we make our way now upstairs to position ourselves very kindly to bring you activities here today. Thanks for watching, and do have yourself a pleasant morning from the Supreme Court of Liberia. So hello folks, wherever you are joining us live from the Temple of Justice in Monrovia. This is a special program. This is a special program for the adjournment of the March AD 2025 term of the Honorable Supreme Court of the Republic of Liberia and the official retirement of Her Honor Siaren G. Yo, Chief Justice, Honorable Supreme Court of the Republic of Liberia. and it's Friday, August 15, 2025. So the program is expected to start at about 10 o'clock this morning, and we are already live from the Supreme Court. But let me just acquaint you with activities. Let me acquaint you with the program. Firstly, there will be the crying of the opening of this section of the court, which will be ordered by Her Honor G.O. Chief Justice. And second on the program today, Her Honor the Chief Justice will request Reverend J. Dua, who is the chaplain of the Supreme Court of Liberia, to lead the court into devotion. And thirdly, Her Honor the Chief Justice will order the clerk of the Supreme Court to call the cases for the delivery of opinions, and the court will recess for 10 minutes, not more and not less, and then the court shall reconvene after the 10 minutes. So there will be an introductory statement coming from Her Honor James Eto Hawa Wolokoli, Associate and Senior Associate Justice, Supreme Court of Liberia, and will be a selection from the Monrovia Community Mass Choir. Tributes will be paid, beginning with Councillor Bono M. Vama, who is the President of the Liberia National Bar Association, and Councillor N. Oswald Twe, Minister of Justice and Dean of the Supreme Court Bar. We also do tribute Her Honor Sianen D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. We also do, and His Honor Yusuf D. Kabar, Associate Justice, the Supreme Court of Liberia. We also pay tributes. Her Honor James Eto Hawa Wolokoli, Senior Associate Justice of the Supreme Court of Liberia, will do as well. And then there will also be another selection from the Monrovia Community Mass Choir, and 6 response will be done by Her Honor Sianen G.O. Chief Justice, Supreme Court of Liberia, and special statement by His Excellency Joseph Yuma Boyka, Senior President of the Republic of Liberia, will be made yet. And also at number 8, Her Honor James Eto Hawa Wolokoli will order the Marshal of the Supreme Court to honorably escort Her Honor the Chief Justice to the ribbon room, accompanied by the Dean of the Supreme Court Bar and the President of the Liberia National Bar, Assistant Court Administrator. And the court will adjourn upon order of the Senior Associate Justice as well. And statements of best wishes, presentation of gifts, and ceremonials and reception will take place in the ground floor or on the ground floor hall and adjacent coast of the Temple of Justice. At the reception hall, there will be arrival and seating of guests, arrival and seating of honorary and Supreme Court justices. Invocation will be done by Reverend Peter C. Logan, Assistant Chaplain, Supreme Court of Liberia. Welcome remarks will be done by Councillor William B. Colley, Assistant Court Administrator, Supreme Court of the Republic of Liberia. Statements of best wishes, diplomatic corps, development partners, and the doyen diplomatic corps, country representatives, United Nations Development Program, and the country director, African Development Bank, as well as the country director, World Bank. Statements of best wishes and presentation of gifts. We will also see Councillor Elizabeth J. Nelson, Court Administrator, Supreme Court of Liberia. Her Honor Nasir B. Sami, President, National Association of Trial Judges of Liberia. Councillor Alex K. Salif, President, Judiciary Staff Association. Councillor Bestman D. Jua Senior, President, National Association of Public Defenders. Councillor Moses Surabi, Executive Director, James A. Pierre Judicial Institute. And there will be a musical interlude at launch, a special statement of best wishes and presentation of gifts continue for 2 minutes each, and there will be selection by the Morovia Community Mass Choir for the third time and presentation of ceremonials. One is Her Honor James Eto Wolokoli, or James Eto Hawa Wolokoli, Senior Associate Justice, Supreme Court of Liberia. Remarks Her Honor Siadan A.U., the honorary, and there will be vote of thanks, which will obviously be done by Councillor Dar Ambrose Mar Senior, Co-Chairman, Retirement Planning Committee, and the benediction will be done by Sheikh Rashid A. Sharif, Assistant Chaplain, Supreme Court of Liberia. And lastly, there will be meet and greet, and photos will also be taken. So this is the official program for today's special program for the adjournment of the March AD 2025 term of the Honorable Supreme Court and the official retirement of Her Honor Siadan G. Yo, Chief Justice, Honorable Supreme Court of the Republic of Liberia. Well, as we speak, we have some members from the legislative branch of government who are already seated. I see Bomi County Senator Edwin Mervyn Snow, Musa Ability of Nema County, a lawmaker is also here, and I see Representative Desin Sibu of District 16, Masurari County, who is also here as well. And I also saw former Associate Justice of the Supreme Court of Liberia, Cabinet Janet. And if you take a look on the far left, you see George Willett of Criminal Code A. And it's and so just adjacent George Roosevelt Willie is so just adjacent the Criminal Code A George Roosevelt Willie is Her Honor Nancy B. Sammy, who is the president of the National Association of Trial Judges of Liberia. Well, let's give you a brief overview of the outgoing Chief Justice of the Republic of Liberia. Recently in her Her Honor Chief Justice Sharon Yo was born on June 26, 1956 in Mosserado County, Liberia. She hails from a large family with reportedly 21 siblings, and her education background, she completed her secondary education in 1974 at the St. Teresa's Convent Catholic High School in Monrovia, and she studied political science at the Cottington University, earning a BA in 1978. She obtained her law degree, the Bachelor of Law, from the Louis Arthur Graham School of Law, University of Liberia in 1981, and was admitted as an attorney at law in the Liberia National Bar, or to the Liberia National Bar, that is, and later becoming a counselor at law of the Supreme Court Bar in 1988. She served as Assistant Minister for Legal Affairs at the Ministry of Justice from 1983 to 1985, held the position of Coordinator for African Affairs at the Ministry of Foreign Affairs from 1988 to 1990, and in the private sector she practiced law as Associate Legal Counsel at the Dere A.B. Jala Law Firm in Monrovia from 1994 to 2000, and she later went to the Central Bank of Liberia, where she served from 2000 to 2003 as Corporate Secretary, Assistant Legal Counsel, and Secretary to the Board of Governors. And the Law Reform Commission, she also served from 2011 to 2013. She held the roles of Acting Executive Director and Commissioner at the Law Reform Commission. And she's been in the leadership in the legal associations in Liberia. The Liberia National Bar Association, she served as Vice President from 1994 to 1989, and later chaired the Judiciary Committee from 2012 to 2013, and also the Association of Female Lawyers of Liberia, AFL. And she is a founding member and is the first vice president, or was the first vice president in 1997 to 1998, and the Maryland County Local Bar Association, where she served as president in 2013. And talking about her judicial career, she once served as Associate Justice of the Supreme Court of Liberia and was appointed in 2013 to the Supreme Court of Liberia, becoming one of the only 2 women on the 5-member bench. And then later she became nominated by the former president George Weah on August 23, 2022 to replace Chief Justice Francis Kokpo, and assumed office on September 27, 2022. And she became the chairwoman in Liberia's history to serve as Justice or Chief Justice after Francis Johnson Addison and Gloria Musu Scott. So talking about her retirement, she reached the constitutional retirement age of 70 on June 26, 2025, and officially stepped down later from assuming responsibilities as Chief Justice of the Supreme Court of Liberia. And she introduced the judicial independence and reforms in her final opening address in March 2025. She emphasized the importance of course delivering impartial justice and staying independent of political influence. And also she brought in the judicial modernization. One person who championed infrastructure upgrades, including a US $3.2 million judicial complex in Maryland County, and improvement to courts and reverses and the Supreme Court building as well. She also introduced a 5-year strategic plan from 2024 to 2029, focusing on modernization, case backlog reduction, training, digital systems, and financial autonomy for the judiciary, commitment to access and equality in the judiciary system, where she advocated for justice accessibility, especially for rural populations, women and children, and continue empowering female legal professionals throughout her career. So she was married to the Senator of Bowman County, Edwin Melvin Snow Jr., who formerly married to the daughter of Charles Taylor. and together they have 10 children, 2 grandchildren. Chief Justice Shannon G. Yo leaves behind a distinguished legacy defined by her background. So yes, and it's 12 minutes past 10 o'clock. We are still watching the official start of the program. So the Chief Justice and Associate Justices just arrived.
Mr. Marshall,
Your Honor,
kindly cry for the next session open.
The Honorable the Supreme Court of the Republic of Liberia, sitting the March 10, 8, 2025, has now met pursuant to adjournment. All persons having business before this honorable court, I am wanting to draw nigh and give the attention, but the court is now sitting and they shall be heard. God save the Republic and this honorable court. Your honors, I have the honor and the honor to announce the opening of this day's session of the Honorable Supreme Court of the Republic of Liberia.
Mr. Chaplain, kindly lead us in devotion.
Your Honors, please permit me if we just sing just a stanza at the chorus of the hymn to God be the glory. We are permitted. To God be the glory, great things He has done. So lovely the world that He gave us His Son. Glory and Son has born men for sin, and holy like Him, that holy, praise the Lord. Praise the Lord. Praise the Lord. Thank you. May I read, please, for our hearing, 2 Timothy 6 to 8. As for me, the hour has come for me to be sacrificed. The time is here for me to leave this life. I have done my best in the race. I have run the full distance, and I have kept the faith.
And now there is waiting for me the faithful price of being put right with God, which is the Lord, the righteous judge, will give me on that day, and not only to me, but to all those who wait with love for him to appear. The word of the Lord. Again, your hands. Please permit me, this is a special day, and I thought to just raise a few points. The text we just read is written by Timothy. It's written to express a sense of completion, perseverance, and faithfulness. It is used to reflect on the life well lived, or a duty or function or task that will be completed. Your Honors, we observe your service with us here. How diligent you have been. But life is a stage. And as the Bible says in Ecclesiastes, there is time for everything. There was a time that we celebrate your coming. And you serve diligently with faithfulness and deep devotion. Now we celebrate with honor and pride as you exit. We thank God for grace for your service here. He has believers. We're so neat. And as I close, let me just say this last time. When the declaration silence was somebody there was a time that you were called to perform the administration of the Oval Office to the President. And as we got up, majestically to move to the pool, two of my friends said, "Wow, she's beautiful and she's young." And they started guessing, maybe she's about 39 something. Fast forward at the delay of time. About a week or two ago, they heard about your retirement. And they said, "Red?" I said, "Yeah, Joe, what's happening?" We are hearing that the Chief Justice is being retired. What's going on? Did she voluntarily give up or what? And I said, "No, it is the law that says she should retire." What's her age? I have not read a portion of the law, but I've been hearing people say at 70. So I said, "She has reached 70 because wow, I heard people say," she said, "Wow, she's too young to be 70. We miss ourselves, and God bless you in Jesus' name. Let us pray. Father, we thank you, Lord, for this day and for every day, for great is your faithfulness. You have been faithful, God. Thank you for the life of a servant justice. I'm dedicating all this back, all of that, to this country, in bad time and in good time. Made all the sacrifices, Lord. Even as you leave the stage, we know that you have a better plan for us. May you lead us, guide us, protect us, and you will always take care of it. We rest and present you the rest of the justices who will continue the work she has left, especially the new incoming Chief Justice. The foundation our sister had laid in the rebranding of the judiciary. May he have the grace, Lord, to continue on that path. Thank you, Lord, for all of them. This is our thanksgiving. And for the rest of the people who are here on this occasion. In the name of the Father, and of the Son, and of the Holy Spirit. And we say, Amen. Thank you, Your Honor.
Thank you, Mr. Chaplain. Mr. Clerk, call the first case.
Just in picture of the large cabinet for this army, Macaulay, Pope, and others, I believe the action of judgment is called for judgment.
Madam Justice Sienna D. Clinton Johnson will speak for the court.
This is a matter before this court that speaks to the motion to join. The facts in this case are that an action of ejectment was filed, the defendant was served, returned served, and the defendant did not file any answer to the complaint. The case progressed until there was an investigative survey done. The court wondered, after putting somebody on bail, denial, and there's no other evidence, why an investigative survey? However, the judge, in her wisdom, decided that an investigative survey is for the court, and so she would need it to aid her in the processes that was before her. So after the investigative survey was done, two of the defendants filed an objection to the survey report and attached a deed. The trial judge declined the contention of the two defendants on the ground that the deed that they have presented before the court did not bear their name. 10 months later, they got another person to use the same deed, go and get letters of administration, and they came to ask to be joined. The trial judge again declined, saying that to allow you to intervene or to be joined at this stage is a clever way to start the whole process for two of the defendants who are your relatives to come back now and get an opportunity to file an answer. So it was declined. So that administrator took an appeal and came up to the Supreme Court. And this court agreed with the trial judge for the soundness of her decisions on the ground that they knew from the very beginning that there was an action of ejectment. They did not act. When they realized that the case was going to proceed, they found a clever way to come back to start the whole process over. And it's the opinion of this court to allow such things to be opening a floodgate where people will sit down. When the case reaches the point, they say we will go and sign it all over. Hence, our judgment. Judgment.
When this case was called for hearing, Councillor Jimmy Sapomo Senior appeared for the appellate. Councillor J. Johnny Momo appeared for the appellee. Having carefully examined the facts contained in the records, listen to the arguments of both sides, and consider the laws relevant thereto in this year by judge. That it is the law that persons who ought to be parties to an action, if complete relief is to be accorded between the persons who are parties to such an action, shall be made plaintiffs or defendants therein. Now, in this case, the deed proffered by the appellant being a same deed attached to the objection to the investigative survey report of the defendants who are parties to the ejectment action, the judge was not in error when she denied the appellant's motion for journal. And our conclusion, however, does not ipso facto preclude the appellant from pursuing an independent action. Wherefore, in view of the foregoing, the ruling of the trial court is hereby affirmed. The clerk of this court is ordered to send a mandate to the court below, commanding the judge presiding therein to resume jurisdiction over this case and give effect to this judgment, because I rule against the appellant. Giving on our hands in the seal of the Honorable Supreme Court of the Republic of Liberia, days 15th day of August, AD 2025. Sam Zeine G.O. Chief Justice, Supreme Court of Liberia. Chief Ethel H. Wodokodi, Associate Justice, Supreme Court of Liberia. Joseph D. Kaba, Associate Justice, Supreme Court of Liberia. Yami Kwekwe, Senior Associate Justice, Supreme Court of Liberia. Senator Clinton Johnson, Associate Justice, Supreme Court of Liberia.
List number 2.
Libyan Terminals Limited by Trades Managing Director, Appellant versus TRH Trading Corporation, appeal grant petition for declaratory judgment is called for judgment.
Mr. Justice Yami Kwekwe, Senior, will speak for the court.
This is an action of declaratory judgment filed before the civil law court. The first summary is that the APN terminal a few years back entered an agreement with the government of Liberia to receive and manage general cargoes. The appellee here is the corporation engaged in the importation of frozen material in this country, frozen food. The APN terminal continue to receive their containers and automatically plug them and charge them $70 US each per day. They inform APN terminal that our container can remain safe for up to 5 days. But if they see 5 days, you can plug it. But don't plug it automatically and charge off. APN terminal refused and says that we have an agreement with the government of Liberia to manage cargo. Besides that, our action is honoring the international best practice. After a series of exchanges, the appellee proceeded to the civil law court and filed for declaratory judgment. The court below declared its right and said that there is no such agreement plus in the agreement between you and the government. Or besides, what you call international best practice is not being domesticated in Liberia. It doesn't apply to this situation. The evidence will not appeal to this court. Concurring the judgment and says that their rights so declared to do so. They are not compared two parties and the agreement. Third party beneficiary cannot be compared with our acquiescence or agreement to comply, and that the agreement in question does have any clause that says that you should plug their container automatically and charge them money that they cannot afford. My other argument is that it is for purpose of health, safety. But we say that is not the argument, that duty is for the Ministry of Health, and there are institutions available for that. The judgment of the civil law court is hereby for friends. That's our judgment.
In this case, it's called for hearing because the MRS seems of the Justice Advocates and Partners Inc. appear for appellant. Considers J. Aware Vacan and Kadatu Todd Nasser of Heritage Partners and Associate LLC in the parties and consider the relevant laws applicable thereto is hereby judged. That when the appellant's concession agreement and tariff guide do not expressly or impliedly grant authority to the appellant to unilaterally plug in containers in his storage without a written consent for approval from the owner of the containers, the appellant plugging in of the beliefs continues against their express consent is a violation of their rights. That in the instant case, there will be no clause in the agreement between the government of Liberia and the applicant APM terminal regarding the plugging of applicants continued. Said action is unauthorized, and the applicant's action of unauthorizedly unplugging the applicant's continues and imposing charges as if were illegal, and the applicants are entitled to legal and equitable relief consistent with law in this jurisdiction. Whereby before going, the ruling of the trial court judge declaring the rights of the appellee to the effect that the applicant's unilateral plugging of appellees continues unwritten instructions and approvals from appellees was contrary to this concession agreement and tariff bar and all applicable laws is hereby affirmed. Hence, the trial judge's ruling of March 16, 2022 is hereby upheld. The clerk of this court is ordered to submit it. Trial court commanding the judge decided therein to resume jurisdiction of this case and give effect to this judgment, cause and rule against the applicant and it is hereby so ordered. Giving order of hands and the seal of the Honorable Supreme Court of the Republic of Liberia is 15th day of August 2025. Signed, Zeyine G.O. Chief Justice Supreme Court of Liberia. Chincheta Howard Woodopody, Associate Justice Supreme Court of Liberia. Joseph D. Kabas, Associate Justice Supreme Court of Liberia. Yamin Kukubensi, Senior Associate Justice Supreme Court of Liberia. Senior D. Clayton Johnson, Associate Justice Supreme Court of Liberia.
Mr. Clerk, call case number 3.
Sona Kamara, Emmanuel Ford, the Princess Court of Kanta, Civil Dima County, Liberia, appellants, but it's the Republic of Liberia by Chukutaro, Denkman, I believe, the people out of the ground of theft property, on the laundering of facilitation, score for judgment.
Mr. Justice Yusuf Jakatem Kaba Alahaji will speak for the court. He just returned from Hajj, so he has that title now, Alahaji.
Thank you, Madam Chief Justice, for that recognition. This appeal was taken from the final judgment of the judge presiding over the circuit court in Kimba County in a criminal case and based on an indictment charging the defendants for the commission of the crime of theft of property, criminal conspiracy, and criminal facilitation. During the hearing of the case, the applicant hearing filed several applications to the court, and the court reacted to those applications in a given way that we discussed in the conclusion of this matter. And in the final analysis, the court entered a final determination holding all of the defendants, that is 3 defendants, Sona Kamara, Emmanuel Court, and Princess Court, guilty of the commission of all of the crimes. From this final ruling, the defendant now appellant brought this matter to this court on the bill of exception based on several issues. One of the issues that were flagged in the bill of exception filed by the appellant is that the trial judge during the hearing granted an application by the state to have the indictment amended to include a new charge of money laundering that was not part of the original charge. The trial judge agreed with the prosecution and allowed the indictment to be amended. The appellant feel that action of the trial court was an error, the person was an error. And we agreed with the appellant that indeed the trial judge was an error when he allowed the indictment to be amended to include the charge. Because the law is very clear, you can amend the environment in the indictment, but you cannot amend the indictment to include a new charge. The trial judge was in error in that area, so we disallowed that new charge that was added by the trial judge's action. The second issue that was raised in the bill of exception was that during the investigation, the defendant was taken to the police and then voluntary statements were made by them. The defendant has said that those voluntary statements were made, therefore they did not want those statements to be used during the trial. But our section of the record is stated the last one was the evidence and analysis of the evidence, whether or not the state established its skills beyond the principle. The defendant made several issues against the final judgment of the final ruling of the trial court. And one among those reasons was that, well, look, there is a law that says that when a matter involves accounting for funds, a criminal matter involves accounting for funds, it is the law that an audit must be commissioned to determine the extent of the criminality of the applicant. But in this case, the allegation of the state was based on a video recording, a CCTV camera that was installed in the business premise, and the recording from the CCTV camera, which was produced, and then the witnesses coming to testify to the footage as to the commission of the crime and the amount that was involved. But the defendant did not produce any counter evidence against this CCTV footage. More beside the defendant himself, in the voluntary statement that he gave to the police, especially the principal defendant, admitted to the commission of the crime. That, along with other evidence that were adduced at the trial, in the opinion of this court, was sufficient in the eye of the law to hold the defendant guilty for the commission of the crime. Another issue that was made, because the court sentenced the defendant based on a new charge that was introduced, that was the money laundering charge, which called for 10 years as the maximum. We said, no, this defendant cannot be brought down guilty for money laundering, because money laundering was not one of the original charges. The highest crime that they were charged with was theft of property, and maximum period of theft of property is 5 years. So they would go to prison for 5 years, and then the other defendant, one of the other defendants that conspired, and conspiracy, the grade of conspiracy is equal to the crime that he conspired to commit. So that too is 5 years. That co-defendant will go for 5 years. The third defendant, we said, where the state did not produce any evidence to link up to the commission of the crime. So we decided that she would be exonerated in this matter. And then that was our determination in this matter.
So this case was called for Councillors John William, Mami, the Congress, Philip, Wakondo, Tia, during the constituency fire, 10, while the original 10 was employed again for the applicants. Having had arguments to review the facts and circumstances within the records and examine the laws controlling the GLR judge. The Criminal Procedure Law revised code Title 2, Section 14.7 acknowledges the right of the prosecution to amend the indictment in certain circumstances. It, however, explicitly states that such an amendment cannot change or add to the charges. Hence, the trial court granting on the prosecution's application to amend the charges against the applicants to include money laundering constitutes a reversible error. That it is track law that issues not raised in the trial cannot at first instance be raised before the Supreme Court. In this case, the applicants not having objected into sections to the trial judge's ruling, backing and admitting into evidence that voluntary statements, this court cannot for the first time entertain any such exceptions raised in the bit of exceptions. The Criminal Procedure Law revised code Title 2, Section 16.10 provides that the court, if it appears that a defendant or the government is prejudiced by a journal of offenses or of defendants in an indictment or by a journal for trial together, the court may order an election or separate trial of counts, granting severance of defendants or provide whatever other relief justice requires. The co-applicant persona Tamara, that having shown any prejudice, she may have suffered as a consequence of a trial along with the other applicants. The trial court committed no error when it denied an application for a separate trial. The law provided the prosecution was the prosecution throughout the trial. In the case of the oral and material evidence used at the trial of the prosecution established that co-applicants persona Mara and Madaput deemed conspiratorial alliance committed theft of property. The prosecution, however, failed to prove this case against Princess support for the commission of the crimes, and as Section 50.5b and 50.95 of the Penal Code provide that theft of property and criminal conspiracy are greater as a second degree felony with the prison sentence of not over 5 years, including restitution of the amount stolen. Wherefore, if you are the foregoing, the final ruling of the trial will affirm with the following modification as follows. A. The co-applicants persona Tamara and Madaput are hereby sentenced to a term of imprisonment for 5 years each. B. That the house constructed for the proceeds of the crimes be assessed and exposed to public sale. The proceeds therefrom be applied against the amount to be restituted, in addition to the $1,897,000 already collected. However, should the amounts so generated not having covered the amount to be restituted, the applicants are ordered to restitute the difference. And C. That the final ruling is reversed as against co-applicant Princess Hope, and she is ordered released without bail. The clerk of this court is ordered to send a mandate to the court below. The judge decided herein to pursue the jurisdiction of this case and enforce discretion in this year as someone. Given on our hands, C of the Honorable Supreme Court of the Republic of Liberia, this 15th day of August 2025. Signed, the NGO Chief Justice Supreme Court of Liberia. Chief Editor, Honorable Body Associate Justice Supreme Court of Liberia. Joseph B. Associate Justice Supreme Court of Liberia. Yahweh Conference, Senior Associate Justice Supreme Court of Liberia. Senator Peter Johnson, Associate Justice Supreme Court of Liberia.
Mr. Clerk, call case number 4.
The estate of Martha Stogofili, Bernard, presented by June based on the schedule in terms of planning, Gemstone, first agreement to test the estate of the kingdoms. Thomas Bernard agreement versus the tested estate of the LP of the view action of the gentleman is for protection.
Madam Justice James Etta Howard will call you to speak for the court. On January 15, 2019, the appellee, the intestate estate of Daniel P. Tucker Bernard, filed an action of ejectment before the 6th Judicial Circuit Court, Montserrat County, against the estate of William Thomas Bernard and Michael Stubblefield Bernard. The appellee alleged that the defendants were in possession of his 12.92 acres of land situated in Congo Town, which included the CDC headquarters. The appellee averred that Daniel and William Thomas Bernard jointly acquired the land in 1956 while they were married. The facts alleged William's death in 1977 of his wife Martha Stubblefield Bernard and his children, that Martha could not legally will the that William could not legally will the property because it was jointly owned, and under the principle of survivorship, it reverted to Daniel upon his death. The appellant, the intestate estate of Martha Stubblefield Bernard, denied the appellant's claims and asserted that the appellant's estate did not exist, having been closed more than 20 years prior. The appellant further contends that the property purchased by Martha was the sole and legitimate property of William Thomas Bernard and not jointly owned. The appellant argued that Daniel, having been alive at the time of William's death and Martha subsequently purchased with respect to right of election under her husband's will, would have objected if she had claim to the property. The appellant also challenged the authenticity of the deed presented by the appellant, alleging it was a product of fraud. It pointed out that the appellant initially proffered a true and certified copy of a deed, which the purported issuer, Julius H. Flomo, denied having issued in a farm affidavit. The appellant then discontinued his case in 2018 and refiled with a new certified copy of the same deed in 2019, but with a different registrar's signature. The trial court ruled, after hearing the trial court ruled for the appellant, primarily reasoning that a renter cannot give away real property to which he does not have legal title, since by survivorship the property became Daniel's sole property, making it legal for title to pass, illegal for title to pass to Martha. The appellant then filed an appeal to this Supreme Court. This court notes with considerable concern the inconsistencies surrounding appellant's deed. For instance, the appellant's second witness, Archibald Bernard, testified on cross-examination that after the appellant, Michael Stubblefield Bernard, won an ejectment case in 2016 against the estates of William Bernard and CDC, he and his siblings formed a deed in their mother and father's name. When they look through the mother's papers, it is astonishing to this court that said he was never proffered with the appellee's complaints. Instead, the appellee attached a true and certified copy of a purported deed to his complaint. Furthermore, the initial true and certified copy of the deed attached to the first complaint filed by the appellee was alleged to have been issued by Julius H. Flomo, acting registrar of deeds at the Center for National Documentation and Records Agency. However, after the appellant challenged this document and submitted an affidavit from Mr. Flomo denying the issuance of this certificate, the appellant discontinued his action. In filing a new action, the appellee attached a certified copy of the same deed, but this time it was signed by a different person, Josephine L. Benson of the Liberian Authority. This court says it was erroneous for the trial judge to even rule that Darlene T. Bernard became the sole survivor of the property she owned jointly with her ex-husband, William T. Bernard, Sr. This court says that when a married couple acquires property, it is held as an estate by entirety, meaning they are considered a single entity with a right of survivorship. However, upon the divorce, this legal unity is dissolved. The property is no longer held as an estate by the entirety, but rather as a tenancy in common, where each person owns an equal share, 50% of the property with no right of survivorship. This therefore means that upon the divorce, Daniel and William each would own 6.46 acres of the 12.92 acres of property, assuming that they jointly acquired it while married. Furthermore, the court notes that even if Daniel had been entitled to half of the land, William's surviving spouse, Martha S. Bernard, had the legal right to take from his share under the 1986 Constitution of Liberia and the decedent estate law. A widow has the right to 1/3 of her husband's or her deceased husband's real estate, and can elect to purchase the marital home as part of her share. In exercise of this right, Martha Bernard petitioned the court electing to purchase 4.23 acres of the property, which included their marital home for US $45,000. This court finds that Martha's right of election was legally tenable, and she had a right of first refusal to purchase the marital home, and those that said right of ownership, having not been challenged for over 30 years, cannot be legally challenged thereafter. Based on these facts, the court finds the lower court's ruling revisable, which found the appellant liable, and says it is contrary to the evidence and controlling law as per the records found in the court. Judgment.
Well, this case was called for hearing. Councillor J. Johnny Moore of the J. Johnny Moore Associates for Chambers and appeared for the appellant. Councillors Rahim G. Sidat Sr. of the Heritage Partners and Associates LLC and A. Lucy Wabdiki appeared for the appellee. Having reviewed the records and contentions advanced by the councils representing the parties and considered the relevant laws applicable, is hereby adjudged. That it is the law that an estate by entirety confers the right of survivorship on the surviving husband or wife. However, upon the dissolution of the marriage, said estate becomes an estate in common and extinguishes such right of survivorship, entitles both parties to equal shares. In the instant case, the allegation by the appellee that William Thomas Bernard and Annette Tucker Bernard jointly acquired 12.92 acres of land while married, and that upon their divorce and the subsequent death of William Thomas Bernard, the 12.92 acres reverted to the Annette Tucker Bernard upon the principle of survivorship. The trial court erred in its determination that the property reverted to the Annette Tucker Bernard in its entirety. The records have revealed that the certified copy of the appellee's deed issued in 2018 attached to the appellee's complaint pointed to various legal and factual inconsistencies the trial judge was in error when he failed to set aside the verdict of the trial jury, and that moreover, the dissolution of the marriage by Daniel and William T. Bernard Sr. rendered the property in tenancy in common and entitled each of them to 6.46 acres of the said 12.92 acres of land presumed to be jointly owned by them. Hence, Martha's Thomas Bernard was properly deeded the 4.23 acres of the deceased husband's property, on which their marital home and surrounding buildings are situated in a fence, having exercised the right of first refusal to purchase their marital home upon election to do so. Wherefore, in view of the foregoing, the final ruling of the Sixth Judicial Circuit, Civil Law Court, of the county is reversed. The clerk of this court is ordered to amended to the lower court, commanding the judge presiding therein to resume jurisdiction of this case and the effect of this judgment. Because I move against the appellee is hereby so ordered. Giving on our hands and seal the Supreme Court of Liberia is 15th day of August 2025. Signed, Zaine G.O., Chief Justice, Supreme Court of Liberia. Chief Editor Howard Woodopoli, Associate Justice, Supreme Court of Liberia. Joseph D. Gaba, Associate Justice, Supreme Court of Liberia. Yami Ogunkwesi, Senior, Associate Justice, Supreme Court of Liberia. Senator Clinton Johnson, Associate Justice, Supreme Court of Liberia. Some component of the city of Morocco Abilene was the estate of Maurice Massacre, the appeal action of damages for breach of contract is called for judgment.
Please be seated, because this is the last opinion on this bench being given by Her Honor, the Chief Justice Siane Jabe Yo, Chief Justice of the Supreme Court. She will be delivering this opinion on behalf of the bench. I have been granted the right to read my opinion in full, since this is the last. This appeal emanates from the final ruling of the Sixth Judicial Circuit Civil Law Court for Monterey County, affirming the jury's verdict in favor of the appellee, the intestate estate of Maurice Massacre, and the award of special damages in the amount of $103,000 United States for breach of contract by the appellant, Samkai Kone. But before proceeding, we take judicial cognizance of this court's records, which show that the parties herein are before the Supreme Court for the second time. The first time was in the case, quote, the intestate estate of Maurice Massacre versus Samkai Kone, Supreme Court opinion, March 3, 2016. When the Supreme Court extensively opined on the justiciability of an action of summary proceedings to recover possession of real property instituted by the intestate estate of Maurice Massacre against Samkai Kone, and a subsequent petition for declaratory judgment instituted by Samkai Kone against the said estate. In the referenced case, this court, speaking through Mr. Justice Philip A. Z. Banks III, opined inter alia that following the expiration of the lease agreement between the intestate estate of Maurice Massacre as lessor and Mr. Samkai Kone as lessee, the latter should have surrendered the demised premises unto his lessor and sought appropriate legal redress if he believed that his lessor, the intestate estate of Maurice Massacre, had violated his right to quiet enjoyment of the subject property pursuant to the lease agreement. that the trial court acted without the appeal of the law when it ruled in favor of Mr. Connor, ignoring possessory right to Mr. Samuel Connor from his petition for declaratory judgment, as the only purpose of a petition for declaratory judgment is to declare the rights of the parties thereto, and that the final ruling declaring the rights of a party is the legal instrument to be employed by the interested party to obtain the enforcement of a judgment. The Supreme Court at that time therefore ordered Mr. Samuel Connor, who stepped and ejected from the subject property, and that the intestate estate of Maurice Massaquoi be placed in possession thereof. Predicated on the Supreme Court's decision in the aforementioned case, the appellee herein, the intestate estate of Maurice Massaquoi, party, a Chinese national, on November 10, 2010 for a period of 5 years at an annual rental. Well, the annual rental is there. The appellee further alleged that notwithstanding the appellant's breach of the lease agreements, specifically the subleasing of the subject properties without the knowledge and consent of the appellee, the latter did not pursue cancellation proceedings, noting that the lease agreements were nearing their expiration. However, the appellant failed and neglected to yield and surrender the subject properties. Instead, continuing to illegally hold over and utilize the said properties to the detriment of the appellee. This conduct caused the appellee to lose income it would have generated under the lease agreements purportedly entered into with the Chinese national. The appellee therefore prayed in the trial court to award it the sum of $113,500 United States dollars as special damages, the amount of $82,500 United States dollars representing an anticipated rental for 5.5 years, during which the appellant illegally withheld the subject premises, and legal fees in the amount of $30,000 United States dollars. In his answer filed on October 20, 2016, the appellant, Mr. Connor, averred inter alia that it was the appellee who had instead breached the lease agreements between them by placing a tenant on the subject properties and receiving rental while the lease was in full force and effect, thus violating the appellant's right to quiet enjoyment of the demised premises. The records show that following the filing of the appellant's reply, both parties filed a series of procedural challenges which ultimately culminated into the case being ruled to trial, with the appellant producing 2 regular witnesses. On the other hand, the appellant testified pro se, that is for himself, and also produced a subpoena witness in person of Beaufort Estamba Senior. Following the trial and the submission of oral and textbook and documentary species of evidence adduced by both parties, closing arguments were had, and the trial judge instructed the jury on the applicable laws. Thereafter, the jury retired to their room of deliberation and subsequently returned a verdict in favor of the appellee, holding the appellant liable to the appellee for the sum of $103,000 United States dollars as special damages. The appellant, of course, noted exceptions to the verdict returned by the jury and filed a motion for new trial, averring that the jury's verdict was contrary to the weight of the evidence because special damages must be pleaded with particularity, a sin must be proven during trial. That the appellant failed to prove any special damages during trial to warrant the granting of special damages in his favor. Subsequent to the filing of his resistance to the motion for a new trial, the trial court entertained arguments pro and con, and thereafter ruled on the motion denying same. The court incorporated in its ruling, which confirmed the verdict to the verdict, in fact, holding the appellant liable for damages resulting from the breach of the lease agreement entered into with the appellant in the amount of $103,000 United States dollars as special damages. And we have quoted excerpts from the final ruling of the trial court. The appellant noted exceptions to the final ruling of the trial court, announced an appeal to the Supreme Court, and thereafter filed a 5-count bill of exceptions, 3 of which we deem pertinent to the disposition of this appeal, as it is within the purview of this court to determine which issues are germane and relevant to the disposition of an appeal. And we have litany of references there. We have also quoted the appellant's bill of exception. Having reviewed the records and considered the alleged errors imputed to the trial judge, we found 2 issues for our consideration. One, that given the facts and circumstances of this case, that the leases between the parties having expired, is the appellee's claim for damages for breach of contract barred by the provision of section 2.131 of the Civil Procedure Law of Liberia, and whether the appellee sufficiently pleaded and proved special damages as required by law to substantiate the award of special damages by the trial jury. In addressing the first issue, whether the appellee's claim for damages is barred under section 2.131 of the Civil Procedure Law of Liberia in the absence of an existing contract, we quote the said provision of the law. Quote, an action to obtain payment of a debt or for damages for breach of a contract based on a written instrument or acknowledgement shall be commenced within 7 years of the time the right to relief approved. Unquote. The records show that the parties entered into 2 separate lease agreements. That the first lease agreement was entered into by the appellee and the appellant on January 1, 2004 for a period of 7 years, which period ended January 1, 2011. The second lease agreement entered into on February 1, 2004, also for a period of 7 years, ended on February 1, 2011. In the contemplation of section 2.13, subsection 1 of the Civil Procedure Law, the appellee has 7 years within which it could institute an action of damages for breach of contract if it was of the view that the appellant had engaged in conduct that was in violation of the lease agreement, and the said 7 years were to commence as of the time the right to relief accrued, which period had not expired at the time of the appellee's filing is action of damages for breach of contract. However, the appellant's contention is not concerned with the statute of limitation, but with the fact that in the absence of an existing contract, the appellee cannot file an action for damages on an expired contract. We disagree with the appellant's interpretation of the provisions of the quoted law, that is section 2.3, subsection 1 of the Civil Procedure Law. And this book says that the said provision of the law is clear that any party alleging a breach of a contract, whether expired or current, can bring an action for the breach of said contract within 7 years after the breach occurs and we so hold. Now, having established that the appellee's suit or case was within the contemplation of the law, we now proceed to determine the second issue, that is, whether the appellee sufficiently pleaded and proved special damages as required by law to have warranted the award of special damages by the trial jury. The Supreme Court has emphasized that special damages, the specific monetary losses that the plaintiff claims to have incurred due to the defendant's action, must be explicitly stated in the pleadings and substantiated with concrete evidence during the trial. Mere allegations without supporting evidence are insufficient because the verdict of the trial jury must be based thereon. And we have the requisite citations. We firstly note that the trial jury granted a lump sum amount as special damages without indication as to what constituted the said lump sum or on what basis the said amount was determined. Similarly, the trial court final ruling provided no clarity as to the various specific injuries that summed up to the amount awarded in favor of the appellee. Neither did the trial court provide any breakdown of the amount constituting the special damages. However, taking cue from the appellant's complaint, this court observed that the prayer for special damages was predicated on the following. 1, the purported rental for 5.5 years at the rate of $15,000 per annum. 2, legal counsel fees in the amount of 30,000 United States dollars and outstanding debt of United States $1,000. The appellee sought to prove his claim of these special damages for these special damages above by initially testifying and presenting into evidence a purported lease agreement he had entered into with the Chinese national. The said agreement was to take effect as of January 1, 2011. We know that when this agreement was purportedly executed by the appellee, the 2 lease agreements with the appellant were still active and in force. Also, the purported lease agreement the appellant relied on to claim damages shows no specific effective date. In fact, the lease agreement is self-serving because there is no testimony by the lessee to that agreement to authenticate its existence, and there is no proof of consideration, i.e. receipt indicating proof of payment for any period of the purported lease. Furthermore, there is no evidence that the purported lease filed any claim. The purported lessee, filed any claim against the appellee, such as an action for specific performance to compel the appellant or the appellee to comply with the terms of the said lease. Neither did the purported lease raise any issue with his lessor, the appellee herein, requiring the latter to comply with the said agreement. Hence, we hold that the purported lease agreement relied on by the appellee to prove that the appellant's conduct caused the appellee loss of rental income in the amount of 75,000 United States dollars was not sufficiently proved to warrant the granting of special damages in that amount, and we so hold. Secondly, the appellee claimed that the appellant was indebted to it in the amount of 2,500 United States dollars, and to prove this allegation, one of the appellee's witnesses, Councilor Joseph Colley, testified that he had convened a conference between the parties at his law firm, and from all species of documentary evidence, it showed that an amount of 1,500 United States dollars was paid. leaving an outstanding balance of 1,000 United States dollars. And this court confirmed, because there were receipts, that this amount of 1,000 United States dollars representing outstanding balances on the rent was the only amount proved as special damages at the trial. Lastly, the appellant testified to have entered into evidence an instrument entitled service invoice bearing the amount of 30,000 United States dollars for legal services rendered by the Winter and Associates law firm to the appellant for a period of 5 years, March 2011 up to and including July 28, 2016. This amount was included in the special damages awarded to the appellant by the jury. This court reiterates the long-standing principle that attorneys' fees are ordinarily not recoverable as damages. As stated in the case Liberia Bank for Development and Investment versus Donzo, Supreme Court opinion, October 3, 2022, such fees may be awarded only when the underlying wrong is accompanied by aggravating circumstances or actual malice, and even then courts are very loath to depart from the well-established rule where a party seeks purely compensatory damages, counsel fees are almost invariably excluded. So we hold here that outside these statutory or contractual predicates, a claim for counsel fees stands or falls with proof of aggravation or malice which does not obtain in the present case, given that the appellee has not asserted either directly or indirectly any malice or aggravation that will necessitate the granting of attorney's fees. Hence, attorney fees are disallowed. Notwithstanding our holding, however, as it pertains to specific damages proved by the appellee at trial, this court takes judicial cognizance of the appellant's wrongful withholding of the appellee's property, seeing having been determined in the case the interstate estate of Morris Massaquoi versus Samuka Connell, Supreme Court opinion, March 10, 2016. In that case, the Supreme Court noted from the records that the two lease agreements that the appellee had entered into with the appellant both expired on January 1, 2011 and February 1, 2011 respectively, that following the expiration of the two lease agreements, the appellant failed to surrender the demised premises to the appellee, but continued to remain in illegal possession thereof from 2011 up to and including 2016, when the Supreme Court judgment in the Massaquoi versus Connell case was rendered and mandated that the appellant be ousted and evicted from the appellee's properties and the appellee be placed in possession thereof. Hence, predicated on the appellant's wrongful withholding of the appellee's premises, damages will attach thereto. And this court, having the authority to enter such judgment as the lower court should have entered, awards the appellee the sum of 50,000 United States dollars for the 5-year period 2011 to 2016 that the appellant wrongfully withheld the appellee's premises. Wherefore, in view of the foregoing, the final ruling of the 6th Judicial Circuit Civil Law Court for Montserrado County is affirmed with modification that the amount awarded by the jury is hereby reduced to the amount of 51,000 United States dollars, representing damages for wrongful withholding, and 1,000 United States dollars, the special damages proved at trial. And This is our judgment.
In this case was called for hearing because Tommy and Dubai appeared for the applicant. Councillor Mole and Virginia appeared for the applicant, having carefully examined the facts contained in the records, listened to the arguments of both sides, and considered the evidence and law relevant thereto in this here by judge. The special damages must be proved by the furtherance of the evidence and with specificity and particularity, and in the instant case, although they are believed pleaded special damages in the sum of 13,500 United States dollars, and the jury awarded 103,000 United States dollars. The evidence presented as trial substantiated special damages in the sum of 1,000 United States dollars. That is called upon in the case the tested Esther Borough Massacre v. Samuka on the Supreme Court opinion March 10, 2016, that Mr. Samuka opponent should have vacated the premises of the intestate estate of Morris Massacre at expiration of the lease agreement, and therefore ordered that the said applicant be vacated and rejected from the appellee's premises. Hence, the applicant having failed to surrender the appellee's premises at the expiration of the lease agreement for the period 2011 to 2016, a total of 5 years, damages were attached for wrongful withholding of the appellee's property for said period. That the damages awarded by the trial court is hereby modified, and the applicant ordered to pay to the appellee the amount of $51,000 United States dollars, representing damages for wrongful withholding, and the $1,000 United States dollars for special damages proved at trial. Wherefore, in view of the foregoing, the final ruling of the Civil Judicial Second Civil Law Court of the company is affirmed with modification that the amount awarded by the jury is hereby reduced to the amount of $1,000 United States dollars. Awarded by the jury is hereby reduced to $1,000 United States dollars, representing damages for wrongful withholding, and the $1,000 United States dollars for special damages proved at trial. The clerk of the school is ordered to send a message to the trial, commanding the judge who decided therein to resume jurisdiction of this case and give effect to this judgment, because and who against the appellant in this year also. Giving on our hands and seal of the Supreme Court of Liberia, this 15th day of August 18, 2025. Signed, Selina G. Yo, Chief Justice, Supreme Court of Liberia. Chief Secretary, Protocol Assistant Justice, Supreme Court of Liberia. Selina D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Not Mr. Justice Yusuf B. Kaba, having decided on this case in the lower court, while serving as a circuit judge, did not participate in the hearing determination of this case, hence he did not sign his judgment.
Councillors, we just need one or two. We need one signature to that judgment, which was inadvertently overlooked. Good morning, CJ. by the authority vested in me by the laws of this land, I hereby announce the formal closing of the March term AD 2025 of the Honorable Supreme Court, Republic of Liberia. Mr. Clerk, you will do separate communications to the President and Head of Government, His Excellency Joseph Newman Boyka Sr. of this closing. Also, similarly, we will write to the Speaker and the Pro Tem of the House of Representatives and Senate, respectively, of this closure. That is, court has closed Senate down to reopen in its October term 2025. Mr. Clerk, we also note that the next justice in chambers as of this closing is Madam Justice James Etta Howard Wolokoli. Mr. Clerk, you shall now retire for recess for 10 minutes more or less, and we will be back for the formal retirement of Chief Justice.
So folks, there you have it, March 10 at the Court of AD 2025 have been officially closed by outgoing Chief Justice of the Republic of Liberia, Chief Justice Siane Yo, and we will take a 10-minute break to resume subsequently for the official program